So, good afternoon, everybody. Thank you for joining. We'll start, I think, probably in about 30 seconds. We'll just let people come into the meeting. So thank you. Let's get started. My name's Stephen Wildblood. I'm going to host this. It is tremendous to see so many people joining this webinar. Thank you. What we're going to do is begin by introducing ourselves, and then we will go on to look at the various issues we're going to be talking about. We're going to be looking at the case of Griffiths, the Toohey and Griffiths case. We'll then discuss clarification questions for about 15 minutes, and then have 15 minutes in discussion on the case of GA and EL. If anybody wants to use the chat facility, please do, and we'll try to pick up the questions from there. And so there hopefully will be time at the end for questions and answers. We aim to finish at about 1:45, so this is a 45-minute session. So let me introduce myself. Many people I think will know who I am. I've just stopped being the designated family judge for Bristol after 10 years. I was in Silk in practicing the family courts for 8.5 years. Before that, I was at the junior family bar for 19 years, called to the bar at the age of 21. That's probably quite enough introduction from me. Alex, over to you to introduce yourself.
Good afternoon, everybody. I'm Alexander Chandler. I'm a King's Counsel at 1KBW. I sit also as an arbitrator, private FTR evaluator and recorder, and I occasionally maintain a blog, which is at familybrief.org.
Roger?
So my name's Roger Isaacs. I'm a partner at Milsted Langdon. I'm a forensic accountant and do a fair bit of expert witness work in the family world. At the moment, I'm spending quite a lot of time representing the sub-postmasters in their claims for compensation, but that has nothing to do with today's talk.
That must be a huge task.
It is indeed.
And Jo, over to you.
Thanks, Stephen. Afternoon, everybody. I'm Jo Grandfield. I am, for my sins, a barrister, collaborative lawyer and family law mediator. Currently, however, a partner in the children and family team at Milsted Reeve in their London office. Great.
So, Alex, we're going to cover those three areas that I set out, are we not?
We are. Well, the overarching theme is challenging experts in financial remedy proceedings, and we're going to focus on a couple of very recent cases. You've mentioned Supreme Court decision in TUI and Griffith, 2023 UK SC 48, which was handed down on the 29th of November 2023, and a decision of Mr. Justice Peel, GA and EL 2023 EWFC 187, handed down on the 31st of October 2023.
And I think we're going to begin by looking at the case of TUI or TUI and Griffiths. And so what happened to bring that case before the court, Alex?
Well, the facts of Griffiths are quite straightforward. Mr. Griffiths went on holiday with his wife and son. They went to an all-inclusive package holiday in Turkey in the well-named Aqua Park Hotel, and he became very ill. He contracted acute gastroenteritis, which he said was the fault of package holiday providers, TUI. He issued a claim. The claim was for about £29,000 worth of compensation and special damages. So the facts were quite simple, but what turned that comparative acorn of a case into the enormous oak it developed into was what happened at trial. So basically, at the hearing, Mr. and Mrs. Griffiths gave uncontested evidence. They had written reports from a gastroenterologist and a microbiologist. Neither of the experts were called to give evidence. TUI didn't call any witnesses, but their counsel persuaded the court that because of deficiencies in one of the expert reports, basically they said that the expert had failed to discount the recurrence of an earlier illness, possibly it was contracted elsewhere. In other words, these were causation points. The judge accepted those criticisms and dismissed the claim. So what caused that rather straightforward civil claim to end up going to appeal once to the High Court, second to the Court of Appeal, third to the Supreme Court? What turned this litigation into a case which took 7 years to reach the Supreme Court was all to do with principles of fairness of the trial. Was the judge entitled to find that the claimant hadn't proven his case when the expert had given uncontroverted evidence? Put another way, if you are going to criticize what an expert says, are you obliged to put your case to the expert? Does the court have to actually have the expert in front of them to be able to respond to those criticisms? It may remind our audience of being in civil litigation classes. Do you have to put your case? And a bit like Stack and Dowden, as well as taking an inordinate amount of time to go to the courts, this was a case in which at every stage, the appeal court disagreed with its predecessor. So Mr. Griffiths won at the High Court. The Court of Appeal found in favour of TUI 2-1, and then ultimately the Supreme Court, Mr. Griffiths was successful.
So it's another snail in the ginger beer bottle type of case, except I think Donahue's case took 4 years to complete, and Mr. Griffith's case took 7. So things aren't exactly improving in relation to delays, are they? But it's a civil case. Why do we need to know about it, being family practitioners?
Yeah, that's the point. I mean, on one hand, the Supreme Court was dealing with some fairly fundamental issues of principle relating to fairness court hearings, relating to whether or not we have to call witnesses and expert witnesses to be cross-examined. So while the family court doesn't apply rules of evidence as strictly as the county court, and while we have different procedural rules, those principles are still relevant. We've also been told countless times over the past decade that the family law is not a desert island. So while there are undoubtedly differences in procedure and approach, these principles do generally apply. Against that, I don't want to overstate the case. The procedure was different. There was a case recently where Lord Justice Ryder said that one has to always be careful transplanting civil authority into family cases. I'm going to quote here: harvesting obiter dicta, expressed in one context and seeking to transplant them into another. That isn't straightforward. Family cases are quasi-inquisitorial, whereas this was a civil claim which was purely adversarial. And obviously, if we in the family court had to apply the same strict approach in terms of putting one's case, imagine how long a final hearing and financial remedies would take in terms of housing particulars, scheduled outgoings, etc. So one needs to be exercise a bit of care in terms of applying this over. And
I think Lord Hodge gave the first judgment, did he not? And what did he say, please? I think you can summarise it. Could you possibly?
Well, I can summarise it, probably not doing justice to what is a magisterial judgment. I mean, Lord Hodge for the court, he confirmed the general rule is that when you are submitting evidence that isn't accepted, you are required to challenge that by cross-examination. So that rule, which may be familiar to all of us, or we may have dealt with at law school, remains the general position. And the reason for that is to ensure that the court process has integrity, to ensure that the court makes a proper assessment of the evidence. It's not always applied, obviously. There are exceptions, and the application of the rule will depend on the circumstances of the case and the materiality of the evidence.
Yeah, sure. But there are some exceptions, are there not, that they mention in the report? I think there are 7, are there not? Oh, I wonder if you can help us.
Yeah, I mean, there are 7, between paragraph 61 and 67 of the judgment. Lord Hodge gave 7 circumstances where that general rule wouldn't apply. In other words, you wouldn't actually need to call the expert to give evidence. Again, a short overview doesn't do justice to exactly everything that was said, but in overview, number 1, if the evidence is collateral or insignificant, you wouldn't need to call the witness. Number 2, if evidence is manifestly incredible, or a challenge by cross-examination wouldn't make any difference to the assessment of the evidence. Number 3, and I'm afraid here we're going to be delving into a bit of Latin, if the expert has made a bold assertion of opinion which is unsupported by reasoning, in other words, if he or she's been dogmatic, and here the Latin expression is ipse dixit, then there wouldn't be any need to call the expert over that. Fourthly, where there's been an obvious mistake on the face of the report, or whether what's been said is patently absurd or inconsistent. Fifthly, if the report is based on factual assumptions which have proven unreliable. Sixthly, where questions have in fact been put in advance of the trial, so the experts had the opportunity to respond to it with adequate time, but has failed to do so. And finally, 7th, where there's been a failure by the expert to comply with the rules, with the caveat, according to Lord Hodge, that some caution needs to be exercised on that, and you might need the direction of the court before the trial if you're going to be going down that line.
Yeah, we discussed that, did we not, before the webinar? And as you know, I think that 5 and 6 need particular caution. So the 5th exception is where the report is based on factual assumptions which have proven unreliable. Of course, you're not going to know whether they prove unreliable until you're within the evidential process before the court. And so to not insist that an expert attends for cross-examination on the basis you're going to prove that his factual assumptions are unreliable has all sorts of dangers attached to it, I think. And also, where questions have been put in advance but the expert hasn't responded to them, I can well imagine that a day or two before the court hearing, that deficiency from would be remedied, or attempts would be made to remedy. And that could cause enormous difficulties with the trial process, because by then it may be that the expert can come to give evidence. So those 5 and 6 I can see can cause difficulties in airing cases. But does that make written questions, do you think, Alex, following the receipt of a single joint experts report, even more important?
I do. I mean, I think if you're in a situation where there's been a single joint expert report, you don't like its contents, to proceed to a final hearing without having raised some very carefully drawn questions and considered the possibility even of calling the expert as a witness, I think is a very risky strategy. So in the first instance, you'd be bound to raise questions. But of course, you've got to bear in mind that the rules are quite clear in terms of the purpose of questions, which are, they are meant for clarification of the existing report. They're not meant to be an opportunity to interrogate the expert, or in a sense, have some sort of early cross-examination. We'll go on to discuss this, but it isn't always easy to discern where that line falls between clarification and questions which are really impermissible. So I'd say Griffiths does underline the importance of putting questions first, but I think it would be very helpful, given that it's generally it'll be Roger as an expert who will receive these sort of questions, and Joe, who probably will be drafting these questions more often than counsel would be, to bring in them for their views at this stage. So perhaps Roger, if I can bring you in for your views on this.
Yes, thank you, Alex. I mean, there is an enormous spectrum in my experience of what I tend to receive when I'm asked questions of clarification. Some parties will ask 1 or 2 questions that are genuinely just trying to clarify things. Other parties will send in dozens and dozens of questions. And sometimes I think that they believe that by preceding a question with the word "by way of clarification," that must by definition mean that what follows is a question of clarification, even if and I'm being slightly tongue in cheek here, but sometimes you will be asked by way of clarification, you've used a multiple of 6 to value the company. Had you used a multiple of 26, what would the result have been? Or you've used the maintainable earnings approach. Just to clarify, if you'd used a completely different approach of net assets, where would you have got to? And the envelope is certainly sometimes pushed to beyond any sense of clarification. And in practice, that puts me as the SJ in a slightly difficult position, insofar as clearly what I want to do is help the court, but equally, it seems to me I could be justifiably criticised by the other side if I were to answer questions that went beyond clarification. And it's fairly clear to me that the ultimate recourse is to go back to court, as I have had to do on occasion, and seek directions. And in fact, I've even had to attend a hearing where we've gone through a rather bizarre process where the judges had to rule on to whether a question which was clearly not clarification was a matter of clarification. And oddly enough, the judge said it wasn't clarification, at enormous cost to the parties. It's usually not a grey line, but a fairly thick black line that divides a genuine question of clarification and a request to completely redo a report on an entirely different basis. But what I wonder is whether this case of Griffiths is going to open the door to the court saying, well, it may not be a question of clarification, but it would be really helpful to know the answer to it, and to what extent we start to see the court giving directions, or even the parties agreeing that questions to be answered that go beyond clarification. Because my starting point is always to say, I've got absolutely no objection to answering your 215 questions, subject to you paying for them, of course, as long as either the parties agree to that happening and there being sufficient time, or alternatively that the court so orders it. But to what extent the court is going to use its discretion, because clearly it may well be cheaper to have the expert answer a question which goes beyond clarification than to have to wait to a final hearing for the SJ to be called to give evidence in person.
Sure. Joe, I don't know if you, thank you, Roger. I mean, that's really helpful. Joe, I don't know if anything you'd like to say anything on this point, please.
Well, thank you, Stephen. I agree with all actually that Alex and Roger have said. I think that questions will become even more important following Griffiths, and there will be even greater need to be really clear about what those questions are and how far their scope is and what it is that they're actually doing. Because one of the issues that we have as family lawyers is that clarification isn't a defined term within the rules. So there equally isn't a huge amount of family case law on what that looks like either. But since the FPR 25.10 is effectively lifted from the CPR, we can look at civil cases to try and get a bit of guidance into relation to what clarification is and what it isn't. So the White Book says that questions shouldn't be asked to require an expert to carry out new investigations or tests or significantly expand on a report, or effectively be cross-examined by post, unless the court gives express permission, and that's quite key. But there's a couple of helpful cases where we've looked at that. There's one of Much and Allen in 2011, which was a personal injury case following a road traffic accident, where one of the questions that had been put to the expert was whether or not the injuries that the claimant has sustained would have been less had they been wearing a seatbelt. And the Court of Appeal said that wasn't a clarification question, and it was outside of the original report and the original instructions themselves. And I'll come back to what we can do about that within the instructions when we're looking at clarification questions. Second civil case is Mustard and Flowers, which was a 2019 case. On that case, the expert went back to the court because the questions that had been asked were numerous, and there was a huge amount of new material and attendant costs involved in having to answer that. And the High Court there ruled that those questions were in effect cross-examination and shouldn't be allowed. So what we take from that, I think, and what we take from Griffiths and what we need to do as family lawyers in the first instance, I think, is that where there is, for example, a variety of ways of calculating business value and adopting multiples or what asset basis and so on, and think about what you're asking the expert to do at the outset. And I think a wider instruction than would otherwise be the case will be certainly a way forward. So if we explicitly ask an expert to consider valuations on alternative bases, for example, then at least you've got something there that if you want to look at or raise questions on, they will be clarifying within the scope of what the report originally was. And that's something that I think we will see more of, or should see more of. What you do when there's a dispute about whether questions are clarification by way of clarification or not. as Rogers has said, we can go back to court in the same way as we do if there's a dispute over a letter of instruction. But we've seen from recent family cases that the courts are encouraging us to use arbitration and other ways of dealing with discrete issues such as that. My colleagues at Mills and Reeve had one case where what happened in that situation was that the court then directed that the questions go back to the expert, and the expert decided whether they were clarification and therefore he or she was going to answer them or not, which was an interesting passing of the buck, one might think. Or the other things we can do, as Roger said, and I think that's a really interesting idea, that the parties agree at the outset that they are going to be and potentially get a direction at first appointment that says the parties will be able to ask questions of the expert by way not only of clarification, but going beyond that on the basis that they each in the first instance pay the costs incurred in doing so. So there's sort of three ways that I think we can get around the issue we have at the moment about what's clarification and what isn't, and what should or shouldn't be answered.
Do you think Griffith is going to lead to more expense for litigants?
I think it may well lead to more front-loaded expense, but in terms of the total expenses, probably not, because if you have a client who doesn't agree or accept what the SJE has said in their report, they will be involving their own expert anyway, or they will be challenging that at a final hearing. So I think what Griffiths may well do is mean that we have to get potentially shadow experts involved earlier in the process than one might otherwise have done. And probably in lots of cases there will be more expense, but not necessarily.
Yeah. Well, thanks, Chair. That's really helpful. And Alex, what can we do to avoid any potential pitfalls?
Well, if I can make a sort of general observation, and this ties in with actually a blog I wrote last week called The Winds of Change, which I do think that judicial attitudes are changing in the family court from the top down, from the top of the financial remedies court. There is an increased expectation that we as practitioners should be aware of procedural guidance, rules, precedents guidance, etc., and comply with that. So as a general observation, I think the courts, I think this is going to trickle down, and that there will be a greater expectation that we do follow the exponential increase in the amount of rules and applicable guidance we have on all sorts of things. So I think courts are going to look increasingly critically as, when were these questions sent? Were they sent in time? Are they properly for clarification? I think the Roger and Joe's about whether the parties can agree to enlarge the scope of that and to put more critical questions is, I think, a really interesting idea. And it may well be proportionate in terms of dealing with the issue then as opposed to a trial, but it obviously would be up with what questions are meant to be according to Part 25. So it's an interesting innovation. But I think generally speaking, we are going to be expected to kind of tighten up in terms of compliance.
Yeah. And do you think this is going to lead to more Danielson-Walker application?
Well, shall I just start off with that? I mean, I expect everybody will be familiar with the expression, but I'm just going to briefly unpack it because it has become a sort of phrase which has become so ubiquitous. It's probably worth just bearing in mind what Danielson-Walker is. It was a decision from Lord Woolf, from what I am amazed to find out is 24 years ago, 2000, one of the first reported decisions following the inauguration of the civil procedure rules, and it's concerned what approach the court should take where one party is unhappy with a single joint expert. Danielson-Walker wasn't a family case. It was a personal injury claim. The claimant had been struck by a car when he was a child. And the key passage in that decision is paragraph 28, which basically says, in a substantial case, for reasons which are not fanciful, that's become the famous phrase, the court may exercise its discretion to allow a second expert. So Danielson-Walker has entered the parlance as a shorthand for applying to adduce a second expert report. These applications have always been extremely unusual. In what the applications may not be so unusual, successful applications have been extremely unusual, where we have always, in family cases, taken a far more, we've been far more strictly, the adherence to single joint expert has been more common than in civil. It's a difficult authority to slot into family cases. The threshold for adducing expert evidence is more stringent in family than in civil, or at least it has been for the past few years. I think successful Daniels and Walker applications are going to continue to be exceptionally unusual in financial remedy proceedings. So save for big money cases in the High Court or cases where something quite significant has gone wrong, I think the expectation is going to be this will continue to be very much the exception rather than the norm. But at least we do now know that Daniels and Walker, we do at least have some recent guidance as to how that civil guidance should be applied in financial remedies.
Well, that brings us on to GA and EL, does it not? Rather, thank you for teeing that up. That's the case that we need to go on to discuss, the decision of Mr. Justice Peel. What does that say about this area?
Well, remarkably, this is the first published judgment in a financial remedies case in 24 years, which considers what test should be when a party seeks to rely on a second expert. In other words, how should Daniels and Walker apply in a financial remedies case? So the issue on that case, and I know that Roger has written a very good blog about this, which you can find on the Financial Remedies website. The issue related to the valuation, a historic valuation of the business. In other words, what had it been worth in 2019? The single joint expert, Grant Thornton, had been asked to produce a present day valuation. In other words, don't look backwards, don't have hindsight. They'd come up with a figure of £18.9 million. Wife in that case wasn't happy with that. She sought to rely on a second expert, Longworth Accountancy. They analyzed it on a different approach. They did apply hindsight. They applied the sort of guidance, or that they adopted the guidance of Mr. Justice Mostyn and ENL, in other words, having issues of hindsight, and they came up with a slightly higher figure of £20.5 million. So essentially, in that case, 3 weeks before the final hearing, the wife made an application to bring in that second witness. Perhaps unsurprisingly, given the difference was only £1.6 million, in other words, about 5% between the two valuations, and given the lateness of the application, it was unsuccessful. The importance of the judgment is really twofold. First of all, the Justice Peel confirms that the starting point is Rule 25.4 of the FPR, and the test is necessity. Now, that may not be much of a surprise, but bear in mind that necessity is not the threshold in civil procedure. So you won't find any reference to necessity in Daniels and Walker. There, the test is whether it's reasonably required. So it confirms that the threshold is for a second expert is necessity. And the second point to note is that in terms of the guidance the court will apply as to how to exercise the discretion, reference is made to the well-known civil authorities, Daniels and Walker, Cosgroves and Patterson. The four main principles which are identified are, firstly, the applicant for the second expert must advance reasons which are not fanciful. That's the Daniels and Walker point. Secondly, the court exercises a discretion whether to permit further evidence. Thirdly, the list of factors from Cosgrove and Patterson, which I'm not going to go through, but it's set out there, which is non-exhaustive, but that should be borne in mind. And fourthly, and Mr. Justice Peel thought particular attention should be applied to this, the overall justice to the parties. So GA and EL is really important because finally we have a specifically family financial remedies case, which sets out how court's discretion should be applied.
Yeah, and I think applying for what we're calling a Daniels and Walker expert is not without its pitfalls, is it? And Roger, as someone who gives evidence frequently in this area, what do you think are the particular pitfalls that you've seen or that you envisage?
Well, for the accountancy expert, the practical pitfall that I have seen on occasion arises when, quite properly, a shadow expert is instructed, often at a relatively early stage, either to help with the drafting of a questionnaire or to help with the drafting of questions. And there can be some entirely candid conversations between that shadow expert and instructing solicitors. In one case, I know that the SJE report was produced, one party wasn't happy, called in a shadow expert, had an initial conference with counsel, and the shadow expert admitted that actually broadly he agreed with the SJE, but that if pushed, he could probably come up with a few arguments that might be worth running. Right. To his horror, the minute of that conversation ended up in the trial bundle. Now, that's a relatively extreme case. And the reason I think it ended up there is because the rules require that the instruction of a Daniels and Walker expert, or indeed any expert, must be disclosed. And it raises the question as to what constitutes the expert's instruction. So either it was an error or somebody decided that was part of the instruction, and that's how it ended up there. But the point that I think it raises is that if you have a shadow expert who is appointed early in the proceedings and who has given some candid and potentially unhelpful advice, and then you subsequently make a Daniels and Walker application, and that shadow expert steps out of the shadows and is thrust into the limelight as a formal expert witness, not only does that raise the question as to what that expert is required to disclose in terms of earlier advice, but also what questions may well be raised in cross-examination by the canny barrister who says, so when were you first consulted on this case, Mr. Isaacs, and what exactly have your opinions been, and have you produced any written advice before you produced your report, and so on and so forth. And I think the last thing that is proportionate or sensible is for parties to have late in the day, having obtained instructions from advice from a shadow expert, to appoint somebody brand new to the case, who heaven forbid might not even agree with the shadow expert and might agree with the SJE. So that's a fairly dangerous path down which to travel. But what I think is incumbent upon all putative experts is to recognize that when they're instructed on a shadow basis, and for their instructing solicitors to recognize this too, that there is a danger that whilst they have the benefit of the shadows initially, those shadows could soon or could at some stage potentially disappear. And it's at least a conversation worth having before a Daniels and Walker application is made, to see whether there are any aspects of the earlier advice that could call embarrassment were they to see the light of day. Yeah, really important points, Roger. Thank you. That's really helpful. And Joe, from the point of view of a solicitor, what are the trips and traps or pitfalls that you
The big one is the one that Roger just alluded to and has illustrated really clearly. I think it sends shivers down my spine. That, you know, when you're talking to experts in the background, if they're ever going to become come out from the shadows, then we need to be really, really clear about what's been said when and in what format and what's going to be disclosable. Because I think that's a real risk, particularly bearing in mind that quite often you can have a shadow expert on the background on sort of an informal basis. You know, if it's the company accountant or it's somebody's friend and so on, and the client will bring them into meetings and so on. We've just got to be so careful. In terms of a Daniels and Walker application itself, I mean, as Alex has already explained, the courts are really reticent to accede to those sorts of requests. And I think that's right, because we have always got to think about proportionality and costs and so on. And when we're looking at certain sorts of reports, so for example, business valuations, we know that they're an art and not a science. We know that there can be lots of different views taken by different experts and in a sense both be right. So we've just got to be thinking first of all about whether or not what we want to do is to challenge an expert or whether we want a wholly new one. That said, I think there are cases where it's right to make an application. So where the reports are about technical issues, so foreign law or an accounting method, where neither party wants to rely on a single current expert, which we've seen in Gallagher and Gallagher, for example. But I think it is always going to be much harder to get your own expert involved, where a report is more of a judgment call or a discretion. And there, I think we come back to the point that we talked about before, about having a widely drafted letter of instruction that can provide for an expert to give a different two different alternative views, for example, that you can then challenge if you need to in cross-examination. One thing that I was sort of when looking and researching in terms of this webinar, actually was looking through the Financial Remedies practice book, which is published by Class. And I know it's not a view that's necessarily held by everybody, but one option might be that if you have your shadow expert and you've got a report that you don't like, step one is for your expert to sit down with the SJE and go through that report, and where there is a disagreement, to see whether those can't be resolved, or at least reduce the numbers of areas of dispute. But whether or not that comes back to your point, Stephen, it's just another additional tier of costs that isn't really going to get you that much further, is I suspect something that there could be a wider discussion about as well.
And I imagine the other party may not be very keen to agree to your expert, your shadow expert, speaking to the single joint expert, and for fear that your expert is going to influence, I'm trying to think of a polite word, influence the single joint expert in a way that would be unbalanced. So I can see that could bear considerable difficulties, could it not?
I absolutely agree. And then we end up with three experts all over.
And then we're back to how things were many years ago when I'm afraid I started at the bar. It's about 40 years ago. So I think that is pretty much coming towards the time, but there are some questions. I'm not sure. Do we have time for the questions? Alex, I think.
I think we do. Stephen, I was just going to mention, by way of sort of a kind of wrapping up of the points we've said, just a sort of personal view. I mean, if you're in a situation where you've obtained an expert report and you're unhappy with it, and this is not making really new, obviously, it's really kind of pulling together a few threads. I think you need to work out what the specific criticisms are of the report as soon as possible. If you've got a shadow report, consider what the lines of attack are. Bear in mind the timescale, which is tight, 10 days under rules. Bear in mind this sort of changing climate, or at least I think it's a changing climate in terms of judicial expectations of compliance. Secondly, sending questions, which to the greatest extent possible can be justified as clarification questions. I mean, obviously, might be jiggery pokery going on there, but if you can somehow say, well, you are really clarifying that, you're not actually putting something which is impossible to explain as a clarification, the way to go. Daniels and Walker, I just think it's always going to be very, very difficult. But at least we now have clear answers to the threshold and as to the court's approach. I mean, in terms of calling experts, I think we all know it's very expensive to have an expert, spend the best part of a day, particularly if you're not, sure as the case management is when they're going to come and be cross-examined. I know from personal experience, it is not easy cross-examining a single joint expert. I mean, it may be a line you have to go down, but I think I'm speaking to fellow advocates here, but be under no illusions how difficult it is to cross-examine a single joint expert who is, able to fight their corner, and it is not easy getting a judge to say, well, I'm not going to place any reliance on this. I'm satisfied that what's been said has been undermined in cross-examination. Not easy, but post Griffiths and TUI, it may be something we have to think about more often.
Do you think people are also going to think about to have shadow experts who are not then the subject of a Daniels and Walker application, but just remain in the shadow throughout because of the need to understand and be able to cross-examine the single joint expert in the way that you've just described?
Well, I certainly do. And I think probably the earlier the better, actually.
Right. Yeah. And I think for me, that's one of the points that may well arise from this decision that we're discussing. But so thank you. Alex, I wonder if you're able to pick up on the questions and answers. I'm afraid I can't on my machine. So under the Q&A.
Well, I can pick them up, and I'm very happy to the anonymous attendee who said they loved my entry with Winds of Change, available on all good computers through familybrief.org. Yes, that wasn't really a question, but thank you for the response. Norman Hartnell asks Stephen what he, as a recently practicing judge, looks for in relation to business valuations. secondly, with the PAG2 report, are we expecting to see more pension experts giving evidence in court?
I think on the latter one, I don't see why we should see more experts giving evidence in court. I think we've had pretty good advice from the PAG2 report about what should be done in relation to pensions. I don't think that should necessarily lead to more experts giving evidence. What do I look for in an expert's report? I think a report that I can understand. And I know that sounds almost Delphic, but I'm not an accountant. I often get masses of documents that I have to read over a very short period. I want an executive summary and I want clarity. And so beyond that, I don't think I'd like to go into specifics. Probably Roger could say more than that about what he would expect to see in a report. But that is the essential point. Please, an executive summary at the start so that I can pick up what's being said very quickly.
Could I just chip in on that? One of the most overlooked rules there is that there's actually a maximum page limit for expert reports, and that's 40 pages. But obviously, the court may exercise discretion and say, well, maybe not in this case. But there's nothing worse than, well, that is a rule which is overlooked, and or it's guidance which is overlooked, and that experts should be informed. It's maximum 40 pages, not including the appendices, obviously, but non-experts, it's difficult if you end up with a book which is incredibly lengthy.
My understanding was actually that 40-page limit does include the appendices, because I regularly, when I'm instructed, say, I suggest you obtain early consent, because certainly if I'm producing a report and you've got a number of companies and a number of financial statements and you've got notes of meetings, if that whole bundle it is to be less than 40 pages, you're either going to have to use a font which is far smaller than that allowed by the family procedures, which has spotted that ruse and ruled against it. But the reality is that even a relatively simple company or business, if you include tax returns and other documents, and it's probably easier to include them in the trial bundle as part of the expert's report so they can be cross-examined than to produce a shortened report and then try to hope that when the bundle's produced, there's some sort of after the event cross-referencing, which is inevitably going to go wrong. And what I try to do is produce a report with all the supporting documentation appended and cross-referenced. And that will inevitably, in almost every business valuation, lead to a report being more than 40 pages.
Thank you. Joe, I don't know if you've got anything to say on that.
I'm a big fan of a summary, as you are, Stephen. I think that's so important at the beginning, a concise sort of overview as to what the report's going to say, but not just for the lawyers and for the judge, but for the clients. Yeah. Because sometimes you have clients who aren't across, not particularly numerate, or haven't been involved in the business world, and they're being asked to accept or look to push back on a report when they don't really understand what it is. And if we're the lawyers trying to explain something to a client because they can't understand it from the report, then we need to have a fighting chance of doing that as well. But ultimately, it's the client that's paid for the thing, so they should be able to understand it.
That's such a good point, isn't it? Because who's the report for? Okay, Alex, I think that we aim for 45 minutes. And I think we pretty much hit that. Is that is correct? So we started at 1:45.
Yes, Eva, I think we're there on time. There's a couple of questions, but maybe we can just deal with those in writing. Thank you.
Okay, so thank you very much indeed to everyone who's attended. I hope you've found it useful. Can I thank those who have been contributing to this? I've had the easy task of just teeing up some questions and then watching the answers on flow from that. And I suppose one moral is, if you're going to drink ginger beer, make sure there's not a snail in it. Okay? All right. Thank you very much and good afternoon.
Thanks, everyone. Have a good weekend.
Good afternoon.
Bye.